Ladies and gentlemen, gentlemen and ladies, ladies and gents, I told y'all this document had some gems in it, and somebody just told me that the website that I sent y'all to download this document had some gems in it, but let y'all see one little gem. Hey, no tax may be imposed on the lands of property of the United States. And in no case shall non-resident proprietors be taxed higher than the residents. The navigable waters leading into the Mississippi and the St. Lawrence and the carrying places between the same shall be common highways and forever free, as well to the inhabitants of said territories as to the citizens of the United States and those of any other state that may be admitted into the Confederacy without any tax imposed and or duty therefore. Ladies and gentlemen, you may think that the Constitution would have gotten rid of this act, but remember, in the 1800s, this was still said to be binding law. As a matter of fact, as I showed you in the previous video, what are you talking about? We don't know what you're talking about. I'm talking about the Northwest Ordinance of 1787. See, Congress did this in their sovereign capacity. This supersedes any act they did in their so-called non-sovereign capacity, their administrative capacity. Watch this so that you see it, so that you get it. See, United States Congress assembled 13th day of July in the year of our Lord, 1787, and of their sovereignty. Okay? They did this in their sovereign capacity. And pay attention, the Supreme Court had already ruled this act to be constitutional. Watch this. Let's do it. No, we can't go there. We're going to go here. Tick-tock, 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 tick-tock. Somebody turn that blinker off. Tick-tock, 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 tick-tock. We're going to go open, 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 open. All right. Now, make sure I didn't make any other mistakes. What was the role of the Supreme Court in the protection of? Supreme Court declared the Northwest Ordinance constitutional, meaning that the lands promised. So, want y'all to pay attention. Tick-tock, tick-tock, tick-tock. Don't know why it's taking so long. Because I got to go lay down. I'm tired, y'all. Unlike verified answer. Oh, no. I didn't want that answer. Didn't want that answer. I don't want to unlock nothing. Y'all just going to take me through those ringers, and I ain't got time for y'all those stupid ringers. Sitting up there, going to get somebody caught up thinking they're going to get an answer when they ain't getting no answer. I need the Supreme Court decision, so y'all give me a second to find that. No, as a matter of fact, let me put y'all, recognize the authority. This is Wikipedia. Wikipedia. This is Wikipedia, y'all. Now no, we got to do it a different way. We can't do it that way because that way won't get us what we need. We got to go here and we got to go zoom. Be glad I ain't playing the Commodores because that's one of my favorite songs by them idiots. I mean, by the Commodores. The idiot was Lionel. So anyway, now, the Northwest Ordinance, formerly an ordinance for the government of the territory of the United States, Northwest River of Ohio. Please understand, it had nothing to do with Northwest of the River of Ohio. That's the thing that everybody's going to focus on because it says Northwest. Northwest is a misnomer because it talked about the introduction of other states into that. Okay, now, find this. It says, consider one of the most important legislative acts of the Confederation Congress. It established a precedent by which the federal government would be sovereign and expand westward with the admission of new states. See, that's the point. Rather than with the expansion of existing states and their established sovereignty under the Articles of Confederation. It also set legislative precedent with regards to the American public domain lands. The U.S. Supreme Court recognized the authority of the Ordinance of 1789 within the applicable Northwest Territory as constitutional in Strutter versus Graham. Strutter versus Graham, 1851, y'all. The Supreme Court recognized it as constitutional as of 1851. Remember, this was not the Confederacy. This was the Second Congress. This is where George Washington was president. This was that Congress. George Washington signed this into law. 1851, but this is before 1871. That's right. That's absolutely right. But you need to understand, when the Supreme Court did this, they did this as the one Supreme Court. See, pay attention. The Supreme Court of the United States, not the United States Supreme Court. Okay? That's what you need to pay attention to. The Supreme Court of the United States. Let's do this. Let's look up this case right here. Okay? Let's chill. Let's settle down. That's what I want to do. Okay, it's just going to make me copy. See, if this was Google, Chrome, I would just be able to click on it and say search Google and it would search. But no, I gotta be in this Internet Explorer junk. I'm trying to get what's that name of that other one that they have? Edge, but I can't download Edge. It's supposed to come automatic, but it ain't coming automatic. It's coming auto Holby. Okay, get out of here, download manager, internet, download manager. Internet, TikTok. It ain't. I already clicked enter. Come on now. All right. I guess it's still searching. Let me pause, y'all, till it gets a still piece of junk browser still pulling up the same page. Was a case in which the Supreme Court of the United States held that the status of 3 slaves who went from Kentucky to Indiana and Ohio depended on Kentucky law rather than Ohio law. Yeah, but pay attention, guys. It doesn't matter what the case was about. It's the fact that they ruled that Northwest Ordinance was constitutional. Okay? Just that simple. Just that simple. That's all we're looking for, is where they said it was constitutional. Let's go here. This is supposed to be, no, we're going to go to the full text. Supreme Justice. Okay, we can go to the full text, not the partial text, the full text. Now, we go back here to Wikipedia, and we got this case, but we don't want this case because we got to pull up the ordinance so that you can understand what's going on with the ordinance. Remember, it says over its applicable territories. See, they're going to make you think that the applicable territories does not include California, Arizona, New Mexico, Texas, Alabama, Louisiana, Florida. It includes all of the territories. See, you see how they say they only want to include these? But it talked about each additional state, and then it says, as Congress choose to expand and make it. I can show you that in a minute. Hold on. Okay? They want y'all to focus on this. This ain't all that deals with. Trust me, people. On August 1789, it was replaced by the Northwest Ordinance. What was replaced? Well, in 1787, law relied on a strong central government, which was assured under the Constitution that took effect the following year. And then it was replaced. See, they made that Confederacy, the Articles of Confederation, they made that, but then they replaced it with this, in which the new Congress, United States Congress, reaffirmed the ordinance with slight modifications. They're correct about that. They did that. Give Wikipedia some credit for that they got it right. Now, let's go down here. Context and history. We don't need that type of context. They talk about effect. Pay attention. This was the original Northwest that they're talking about. Let's get the map. Okay? This was the original Northwest. Okay, that the Mississippi, where's the Delta? Anyway, okay. Now pay attention, y'all. This down here was not included. This over here, not included. Not included at all. It was supposed to expand westward. That's the whole idea of the ordinance. These were the only 13 colonies. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14. Anyway, 13 colonies, people. The original 13. These don't have names because they weren't colonies. Don't have a name, wasn't a colony. Doesn't have a name, wasn't a colony. Colony, 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 colony. That's why they got names. 13 colonies. Okay? They were colonies, not states yet, even though they referred to themselves as states. Okay? Yeah. Okay. Now, pay attention. What individuals needed to understand, because they claimed they established ownership of state lands and territories and all that. They didn't establish anything like that. Okay? What they did do was they were establishing this thing they wanted to say was a constitution, but they were making it so that only the rich people would have rights. Only the rich people would be in control. That's why the governor had to have at least 1,000 acres of land that he controlled. See, if it was the fact that a person just had to be a landowner in order to run for office, then anybody could have run for office who had ownership of land. But no, back then you had to own a certain amount of land in order to be in a certain position. Now you can see why it wasn't ran constitutionally, it was ran special interestly. Okay, because the person in charge controlled everything. The governor had to have 1,000 acres. That means he controlled what was going on in those states, which is why things ran so backwards back then and why they continue to run so backwards, which is why they allowed Jim Crow. Okay? Now, we got this natural rights thing. See, the natural rights provision of the ordinance foreshadowed the Bill of Rights. It didn't foreshadow the Bill of Rights in the First Amendment of the Constitution, trial by jury and all that. Because again, pay attention. Y'all need to know. Y'all need to understand. Let's go to the case so you can get it. This case happened in 1851. These are slaves in 1851. Do you understand? 1851. This is not a slave who was in 1879, 1887. This is 1877. This is 1777. 1787 is when the law was first brought about. Ladies and gentlemen, this is 1851. Okay? The Supreme Court in 1851 said that law was constitutional and still binding. Whether slaves who had been permitted by their masters to pass occasionally from Kentucky into Ohio acquired thereby the right to freedom after their return to Kentucky. Because why? Ohio was a free state according to that act. So let's find out what the Supreme Court had to say about that act, because we don't want to mislead nobody and send y'all down the wrong road. We're going to do Northwest. Okay, it talks about Northwest Territory, okay? Act of Congress passed under the present Constitution, passed under the present Constitution, passed under the present Constitution. Okay, here. Such a provision of the ordinance as are yet in force owe their validity to the acts of Congress passed under the present Constitution during the territorial government of the Northwest Territory and since to the Constitution and laws of the states formed in it. The states were formed as a result of the ordinance, just like the ordinance says, which means it applies to all of those states that were created after the ordinance. Okay? Oh, I like this right here. Let's hold on. The laws of Kentucky alone could decide upon the domestic and social conditions of the person domiciled within its territory, except as far as the powers of the state in this respect are restrained and duties and obligations imposed upon them by the Constitution of the United States. There is nothing in the Constitution of the United States that can in any degree control the laws of Kentucky upon this subject. but it talked about how they received what they received through that ordinance. Okay? And oh, there you go, the Judiciary Act. Under the 25th section of the Judiciary Act, this court has no jurisdiction over the following question, vis-a-vis. Okay? Whether slaves who had been permitted by their masters to pass occasionally Kentucky onto Ohio acquired thereby the rights to freedom after being returned to Kentucky. Because when they went into Ohio, they were free. When they came back into Kentucky, they came back as free. That's what the argument was. Pretty good argument, but wrong type of individuals to be bringing the argument, because remember, the judges of the court were the rich, non-slave people. All right, let's get here so we can find the other Northwest. They don't talk, it only mentions it once. Lord have mercy. I only see it, oh, there it is. But it seems to be supposed in the argument that the law of Ohio upon this subject has some particular force by virtue of the Ordinance of 1787 for the government of the Northwest Territory, Ohio being one of the states carved out of it. One of the articles of this ordinance provides that there shall be neither slavery nor involuntary servitude in said territory, otherwise than to punish for crimes whereof the party shall have been duly convicted, and blah, 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 blah. And this article is one of the 6 in which the ordinance declares shall be a compact between the original states and the people and the states of said territory, and forever remain unalterable unless by common consent. Ladies and gentlemen, this makes that ordinance binding. The argument assumes that the 6th article of the ordinance declares that the perpetual, see, I told you it's perpetual, are still enforced in the states since formed within the territory and admitted into the Union. That's exactly the point. However, let me make sure y'all understand what these idiots in the Supreme Court are saying. Let's go here because this is what I told y'all. From this proposition if this proposition could be maintained, it would not alter the question. For the regulations of Congress under the old Confederation and the present Constitution for the government of a particular territory could have no force beyond its limits. It certainly could not restrict the power of the state wherein, oh, I see the question now. The individual slave was saying since they went to Ohio, and Ohio recognized under the ordinance that no one was a slave in Ohio, Ohio's law deemed them free. And they had not escaped because the law said they had to have escaped. If they escaped, they could be returned. But they didn't escape. They had visited with their master's permission to Ohio, returning to the original state of Kentucky. They're saying, no, you can't do that. You can't make us slaves no more. We're free. Master, I's free. See, I's free. Look, Ma, I's free. Okay, that's what was going on here. Good question by these individuals. That's called logical thinking. And the fact that they were slaves and they were able to understand the law because somebody in that free state told them about this. Because remember, they weren't permitted to read. So how did they know how to bring such an argument? Somebody like me had to tell them that. So pay attention. It is true that the question in that case arose in Louisiana. They're talking about this case right here. But the Act of Congress of April 7, 1798, Chapter 28, Statute at Large, 1 at Section 549, extended the Ordinance of 1787 to the then territory of Mississippi, with the exception of anti-slavery clause, and declared that the people of that territory should be entitled to and enjoy all the rights and privileges and advantages granted to the people of the territory northwest of Ohio. And by the act of March 2nd, 1805, Statute at Large 2 at Section 322, it was enacted that the inhabitants of the then territory of Orleans should be entitled to and enjoy all the rights and privileges and advantages secured by the Ordinance of 1787 and at that time enjoyed by the people of the Mississippi Territory. Do you see what they were saying? Please understand that this is after the Constitution was written, that Congress has agreed that the act was constitutional. 1851, this Supreme Court agreed that the act was constitutional. The only problem is Congress did not have the right to make exceptions to the act. The act prohibited that. The only way the exception could be made was by common agreement. Okay, this opinion is indeed confirmed or confined to the territory in which the case arose. No, because it was done under common law. Let's make sure you guys understand that. Do not let this court, this backwards Supreme Court, tell you that it was only subject to a certain jurisdiction. How do we know? How do I know? I want to know. Don't touch the feeling. How would I know? Anyway, ladies and gentlemen, we want the rules. No, the jurisdiction of common law. Common law jurisdiction is what we're looking for. There's that no slavery be returned thing. See, no slavery, involuntary servitude, but slaves escaping into the territories must be returned. That's the issue. Okay? But that's not the one I'm looking for. I'm looking for this one right here. And what we do right here, common law jurisdiction. We got to go back to this one right here. Okay? Pay attention. There shall also be appointed a court to consist of 3 judges, any 2 of whom form a court, who shall have a common law jurisdiction. Okay? This was done under common law. That was the whole purpose of this. We got common law jurisdiction. Let's get rid of the jurisdiction, because I put common law jurisdiction in for a reason. Now, let's go here. Pay attention. The inhabitants of said territory shall always be entitled to the benefits of writ of habeas corpus. Always be entitled to the benefits of writ of habeas corpus. Not that the habeas corpus should be suspended, ever. It said they should always be entitled to writ of habeas corpus. Pay attention. And a trial by jury of a proportionate representation of the people in the legislature. Proportionate representation of the people in the legislature and of judicial proceedings according to the course of common law. I'm not making this up, people. It's right there. I promise you. Take a look at it. Nobody else, I ain't seen nobody else talking about this. Somebody talked about Gene Keaton. Somebody sent me an email talking about Gene Keaton, talked about the one United States court being the Supreme Court. Ladies and gentlemen, all I'm doing is explaining to you that they keep trying to tell you they suspended the Constitution. They could not suspend the Constitution. The lawsuit that I'm getting ready to bring up, pay attention, I want y'all to see, because y'all got to see. I'm at 103 down here. We're about to, and 101 ain't filled, so, but we're about to fill it. Okay, pay attention. That's how far we're at. We're going to be at 105 in a minute. That's how far, but we're dealing with the act right now. That's the part I'm on. And I'm talking about the right to a common law jury. The court is going to try to ignore this, but my job is to put them in the same, hold on. My job is to put them in the same bind that the person who helped these two, well, this black man, the person who helped him, this is what my job is to do, is to come at them the same way. Pay attention. They were coming at them because they used the actual technicality. They weren't escaped slaves. So when they went into Ohio, the state declared them free because there was no slavery in Ohio. Although the people in Ohio to this day act like people of color are slaves. Don't worry about it. I know you. I got all kind of amens. I got all kind of ain't that the truth coming over the screen right now. Y'all sitting up here telling me about how they treating y'all in Ohio. I already know how they treating y'all in Ohio. And they bring in LeBron James to appease people as if that Negro can do anything. Should I have said Negra? Okay, that Negra could do anything. If those of you who don't understand what the word Negra means, it means black. Okay? It's a Latin word. Go ahead and look it up. Negra. Okay? Well, that Negra. I tell you, don't worry about it, all right? Just because they do that doesn't take away the fact that they are doing it. But it is evident that the ordinance, let's do this so you guys can see it a little bit better. There's no reason for me to be the only one seeing it, okay? So we ain't going to take it too high because We don't go like that. I don't smoke, so we ain't gonna get high, y'all. We ain't gonna take it that high. All right. But it is evident that the ordinance could not be enforced in the states formed in the Northwest Territory, and at the same time not enforced in the states formed in the Southwest Territory. Exactly. To which it was extended by the present government. Why? Because the ordinance said it had to be extended to those states who wanted to be part of the Union, and as long as they wanted to be part of the Union, they had to accept the ordinance. For the ordinance and the pledges of the Congress of the old Confederation cannot be more enduring and the obligatory than those of the new government, nor can there be any reason for giving a different interpretation of the same words used in similar instruments, because the one is by an old confederation and the other by a present government. And when it is decided that this ordinance is not enforced in Louisiana, it follows that it cannot be enforced in Ohio. Did you see what they just said? So y'all can't have it both ways. So the ordinance, if it's enforced in Ohio, it has to be enforced in Louisiana. That's what the Supreme Court decided in that Louisiana case. But the whole question upon the ordinance of 1787 and the acts of Congress extending to the other territories afterwards acquired was carefully considered in Pollard versus Hagen. Okay? The subject is fully explained in the opinion pronounced in that case, with which, and see, I used to say things like with which or to which, and people tell me, no, that ain't not a way you put words. You don't do that. With which we concur. And it is sufficient now to refer to the reasoning and principles by which that judgment is maintained, without re-entering again upon a full examination of the question. Indeed, it is impossible to look at the sixth article, which are supposed in the argument to be still enforced, without seeing at once that many of the provisions contained in them are inconsistent with the present Constitution. And if they could be regarded as yet in operation in the states formed within the limits of the Northwest Territory, it would place them in an inferior condition as compared to those other states subject to the domestic institutions and the municipal regulations to the constraints of supervision and control of this court. The Constitution, in the language of the ordinance, adopted the common consent, and the people of the territories must necessarily be regarded as parties to it. Oh, I like that. I like that. But however, hold on, and bound by it and entitled to the benefits of it, as well as the people of the then existing states. It became supreme law throughout the United States, and so far as any obligation of good faith had been previously incurred by the ordinance, they were faithfully carried into execution by the power and authority of the new government. That's what you want to get, y'all. Did y'all just hear what they just said? See, it became the supreme law of the land throughout the United States. What they did is they took that ordinance and incorporated it into the Constitution. The fact that when the Constitution was adopted, the settlement of the vast territories was hardly begun. Okay, and the people who filled it and formed the great and populous states that now cover to become inhabitants of the territory after the Constitution was adopted and migrated upon the faith that its protections and benefits would be extended to them, and that they would be in due time, according to the provisions and the spirit, be admitted into the Union upon equal footing with the old states. For the new government secured to them all of the public rights of navigation and commerce, which the ordinance did and could provide for, and moreover extended to them, when they should become states, much greater power than their municipal regulations and domestic concerns than the Confederation had agreed to concede. Exactly. Now, hold on. The sixth article said to be perpetual as a compact are not made a part of the new Constitution. They certainly are not superior or paramount to the Constitution and cannot confer power or jurisdiction upon this court. The whole judicial authority of the court of the United States is derived from the Constitution itself and the laws made under it. However, not true. The Constitution, when it created the power of the Supreme Court, it gave the power only to one Supreme Court, which is why the individual said exactly that. Okay. It is undoubtedly true that most of the material provisions and principles of this sixth article, not inconsistent with the Constitution of the United States, have been established law within the territories ever since the ordinance was passed, and hence the ordinance itself is sometimes spoken of as still in force. But these provisions owed their legal validity and force after the Constitution was adopted, and while the execution, with some modifications which were necessary to adopt its form of government to the new Constitution. And in the states since formed in the territory, these provisions, so far as they have been preserved, all own their validity and authority to the Constitution of the United States and the constitutions and laws of the respective states, and not to the authority of the ordinance of the old Confederation. As we have already said, it ceased to be enforced upon the adoption of the Constitution and cannot now be the source of jurisdiction of any description of this court. In every view of the subject, therefore, the court has no jurisdiction of the case, and the writ of error must, on that ground, be dismissed. Ladies and gentlemen, this is what they're saying. They're saying that the ordinance does not exist. The ordinance is not in force. However, it is existing. It is in force. Why? Because they have said it, not me. The fact that they are still relying, and the fact that owe their validity and authority to the Constitution of the United States, no, pay attention. You see, it says the act of Congress which concluded the ordinance and carried this provision into execution with some modifications which were necessary to adopt the form of government of the new Constitution. That's right, it's the foundation for the Constitution. So the fact that they relied on it when creating the Constitution, they relied on that ordinance, it remained the footing of the Constitution. And let me make sure you guys understand, this is what the person didn't argue, and this is what I argue. Hold on. No, we're in the right document. I was going to say, I want y'all to go up to the top, and I want y'all to pay attention. I want y'all to see my argument. The United States Congress did this in their ordained capacity. They did this knowing full well of the Constitution. Remember, they were forming a temporary government. And as long as that government was temporary, that's what this was all about. This preceded the Constitution purposely. This was not in addition to the, what's that thing called? The Confederate. This was its own ordinance. Let's prove that to you. When this was formed, pay attention, be it done by the Congress in their sovereignty. This was never repealed. They would have had to repeal this because this was an act of Congress. Congress could not just create a new constitution, thereby getting rid of the ordinance, because they would have to do this, be it ordained by the authority aforesaid, that the resolution of the 23rd of April 1784 relative to the subject of this ordinance be and the same are hereby repealed. So the only thing they repealed was the resolution of the 23rd of 1784 relative to the subjects of this ordinance were repealed and declared null and void. That's what Congress would have to do. The Supreme Court couldn't do that, and the Constitution didn't do that. Okay, now watch this. Let's do this so y'all can see. We did common law. Okay, we got constitutions. Understand. And for extending fundamental principles of civil and religious liberties, which form the basis whereon these republics, their laws and constitutions are enacted, to fix and establish those principles as a basis of laws, constitutions, and governments. See, they anticipated that there would be other constitutions, but in no time did they say that this particular agreement would not be permissible, would not be perpetual. That's why they made it perpetual. So nope, you can't have your cake and you can't eat it too. Okay? Now, pay attention. The said territories and the states which may be formed therein shall forever remain part of this confederacy. Okay, my bad. And the United States of America, subject to the Articles of Confederation, and to such alterations therein as shall be constitutionally made. See, such alterations, but in no way did they say that they were getting rid of this. And there is no law, no constitutional amendment, no statute where Congress has deemed this law void. Go ahead, do your research. I don't know. I am just seeing this law for the first time. But pay attention so that you get it. Whenever any of the said states shall have 60,000 free inhabitants, men, such state shall be admitted by its delegates into the Congress of the United States on an equal footing with the original states in all respects whatever. In other words, meaning if they wanted to be a part of it, they couldn't have slaves. What happens is Congress came in later and admitted Mississippi and Louisiana, with the exception allowing them still to have slaves. Okay? When they couldn't do it because this thing prohibited them from doing it. The Supreme Court acting as these white slave owners, because that's what they were. Sorry, it's just the facts. You see, these were the rich men who had over 1,000 acres of land who were part of the Supreme Court. Don't believe me, do your research. I ain't done the research, ladies and gentlemen. I haven't done the research, but I know better. I know you didn't make it to the Supreme Court because you were poor. Go ahead and see whenever a peasant has made it to the Supreme Court. Okay? Sotomayor, take a look at her. She's not poor. Kagan, not poor. Scalia, he's just dead. He wasn't poor. Well, I guess he's poor and dead now because you can't take it with you. Anyway, provided that the Constitution and the government so to be formed shall be republican and in conformity to the principles contained in these articles. That's what they did. And so far as it can be consistent with the general interest of the Confederacy, such admission shall be allowed at an earlier period, and when there may be less numbers of free inhabitants in the state than 60,000. Pay attention. The Supreme Court has just let you know that don't pay attention to me. Let me take you there. I'll take you there. Notice what the Supreme Court said. Carried to its provisions into execution with some modifications which were necessary to adopt its form of government to the new Constitution, and in the states since formed, in the territories, these provisions, so far as they have been preserved, owe their validity and authority to the Constitution of the United States and not to that stupid ordinance. That's a lie, because according to the ordinance, the only way they could create that Constitution, see, shall have the liberty to form a permanent Constitution and state government, provided that the Constitution and the government be formed shall be republican and in conformity with the principles contained in these articles. Why? Because this was an article that could not be nullified. It could not be voided out. It could not so summarily be dismissed. That's the point. That's the validity of this ordinance, and that's the argument. Okay? They couldn't get rid of this, which is why they didn't. The Supreme Court couldn't get rid of it, and the Supreme Court couldn't explain how it was gotten rid of. This is the wording of the act. So what's happening is that the Supreme Court back then said that it was constitutional, that they had the right to do it, but then they said, well, it didn't apply anymore. Sorry, wrong. It does apply, because the wording of it said it had to apply. Congress would have to have nullified this act, as they did with the act that they spoke of. Hold on, so that y'all get it. The same as they nullified pay attention, the 23rd of April, 1784, the resolution, the same as they nullified that, okay, they would have had to nullify this ordinance. Go ahead and see if you can find where Congress nullified the Northwest Ordinance. Now remember, the reason why the Northwest Ordinance applies to everyone, including that case where the Supreme Court, as prejudiced as they were, because remember, they were supporting slavery at that time, so the Supreme Court, get out of here. The Supreme Court did not have any feelings, any type of respect for those slaves. That's why they allowed them to be beaten. That's why they allowed them to be treated. That's why they allowed them to be hunted, because they didn't have respect. They had that, I'm in a white man's state of mind, okay, mentality. So the argument here, and that's what you all need to know, just because they say something doesn't make it true. But they couldn't come and say that that law was what it was, because could you imagine all of the slaves that were visiting in those free states, because they needed that to do their transport, do their travel. That's why they allowed their slaves to travel to those other states, because they were transporting goods. They didn't want to have to pay for somebody to transport it at the border. That's why the Supreme Court made that decision. So they had to allow them to go to those other states. So when this case came up, I guarantee you it wasn't a small case. I guarantee it was being talked about throughout the entire country. When this case came up, the Supreme Court had to come up with a reason for not allowing the case to go through. And what did the Supreme Court say? What did they say? They got their authority from the Constitution. Well, the Constitution gets its authority from this act. Pay attention. The Constitution gets its authority from this act. The Supreme Court said in this right here that they did not have any jurisdiction. Okay? Don't you give me any of that jurisdiction. Okay, that's from the, see, has no jurisdiction over the following question. They said because of the Judiciary Act, this is common law. This was, oh, no, I'm sorry. This was not a common law. No, this was a common law thing because they brought up the ordinance. The ordinance was made under common law. Of course the court had jurisdiction. The Judiciary Act, the foundation of the Judiciary Act was that act. Interesting, ain't it? So now I got to explain that in my motion to make sure they understand. And I got to bring out exactly what the act says. See, I'm so glad we did this. I'm so glad we had this time together. Okay, Carol Burnett. Ladies and gentlemen, I'm so glad I did this because without this, see, provided that the Constitution and the government to be formed shall be Republican. Look, remember, they were doing a temporary government. So it says the liberty to form a permanent constitution and state government. Okay, however, if the state government did this, they would have to follow this. This was the thing that made all state governments follow the Constitution. This was the basis and formation of the Constitution. That's why it had articles. That's why you see it sounds very similar to the Constitution that was written. They just wanted to get rid of the slavery thing. Okay? That was the issue. That's what they were going after. That's why you see when they came up with the Constitution, it wasn't included about slavery. Remember, they only came up with the 10 amendments originally. It did not include anything about slavery. It gave everybody the right to property. It made sure that it listed property. It didn't tell you what property was. It just made sure it listed property, and at that time, people were considered property. That's what they were doing when they came up with the so-called Constitution, but they couldn't get rid of it. Why? Because the people didn't read this thing. Okay, but you had somebody there in Ohio that said, hey, no, you're in Ohio now. No, what you can do is you can just sit up there and stay. If you go back free, but I wouldn't go back. What you mean you got to go back because your people there? Man, you better leave that wife and kid alone. Better let somebody else take care of them. They ain't going to give you no child support. Shoot, you sit up here and you send money back to them when you can. What you mean they just going to take it and beat them and kill them and all? Don't worry about that, man. You free. That's the conversation that would have been going on. But I promise you, if you want to know about your trust, if you want to know about the cess decay and all of that stuff and how everything is set up with your estate, this is the paragraph you want to read. It's the very second one, ladies and gentlemen. They go right into talking about the decedent estates. Okay? They go right into talking about decedent estates. And this is, they talk about intestate. Estate shall have, so the sister of the estate shall have in equal parts. Estate for life. Real estate. See, they actually use the term real estate. Personal estate. I would go over this because this is where you're going to find out how they got everything started. Okay? That the estates of both resident and non-resident proprietors in the said territories, okay, I will go over this. This is going to give you an understanding. This is the foundation for the Constitution. Everybody thinks the Articles of Confederacy the Articles of Confederacy came first. The Northwest Ordinance came second. But the Northwest Ordinance made itself binding on everything. That's what they were trying to do. When they came up with this, they were trying to make sure nobody altered or changed anything. because they know how, people with money like to do things like that. All right. Here's your second rendition and explanation of the Northwest Ordinance, which I think the information might prove to be very helpful if you know how to bring the argument. I've already explained how I'm bringing mine. You got to get yours. I'm going to bring mine. All right? Got to go. Got to go. Got to go. Have a good day. Good night. Goodbye.